Well, tonight's program is the Barrister's Civil Litigation Series, The Trial Process. With our three wonderful speakers in the center, Judge Joe Hiberman, to my left, your right, Steve Young, and right here next to me, Jonathan Stein. Judge Hiberman served Hilberman, I appreciate that. I do need a correction now and then. Served on the LA County Superior Court from 2002 through 2009, following a 27-year career in civil litigation. He is currently a full-time mediator, arbitrator, and discovery referee with ADR Services, Inc., handling employment, professional liability, tort, business, real estate, homeowners association, and related disputes. He was recognized by the LA chapter of ABOTA as Jurist of the Year. In 2008 by the LA Daily Journal as one of the 50 best jurists in California in 2009 and 2010. His articles have appeared in publications of the Association of Southern California Defense Counsel, the Consumer Attorneys Association of Los Angeles Lawyer, published by the LA County Bar Association, and Trial Talk of the Colorado Trials Lawyers Association. He is also a frequent lecturer on topics of mediation and litigation. He serves on the board of directors of the UCLA Alumni Association and the UCLA School of Law Alumni Association as past president, and the Los Angeles chapter of the American Board of Trial Advocates. Mr. Jonathan Stein, of counsel of Firestone and Richter, is the current BHBA litigation section chairman, and he has been practicing for over 25 years. Concentrating his business litigation and gaming law, he has won 11 seven-figure litigations in the last 12 years. His overall record in litigated matters in the last 18 years is 56 wins and 6 losses in lawsuits in California, Florida, Idaho, New York, Delaware, Arizona, and South Carolina. He attended Harvard College, BA 79, magna cum laude, University of Pennsylvania Law School, 83, Law Review, and trained in national law firms. Jonathan recently was dinner chair for the inaugural Litigation Section Awards dinner honoring retired California Chief Justice Ronald M. George and Roman Silverfeld, where the U.S. Supreme Court Justice Anthony Kennedy was a presenter. And last and not least, of course, Mr. Steve Young of Freeman, and Smiley. He's the former BHBA litigation section chairman. Has been a practicing attorney for over 37 years, concentrating on litigation, general business, entertainment, intellectual property, and real estate matters. He has tried in excess of 100 trials in state and federal courts, both jury and bench, as well as representing clients in numerous arbitrations. He has handled a number of state and federal court appeals. His track record of successes in trial and arbitration is well over 90%. He attended UCLA, Bachelor's in Political Science in 1970, and the University of Southern California Law School, JD in 73, and Law Review. He has previously served as the chairman of the litigation section and served as editor of the BHBA's publication, Anatomy of a Lawsuit, 97 and 98. We would also like to thank Meyer, Hoffman, and McCann, forensic accountants, for their sponsorship of this litigation series. Thank you very much.
Our pleasure.
We would also like to thank Freeman, and Smiley for their generously compiling tonight's materials that are before you. Please write down any questions and save them for the end of the presentation. I'm now going to turn it over to Mr. Stein. Thank you.
That was very nice, Anton. Thank you. This is a very interesting time because it's a chance where you see the rubber hits the road. And I don't mean that only because Steve Young is chairman of the Peterson Museum, Automotive Museum, but because most of the time that you're practicing, you do stuff that you think is important. Discovery, responses, motions to compel, argument on demurs, complaints getting amended, problems with witnesses that don't show up. After all that stuff is done, you realize about 80% of it, maybe 90% of it, doesn't matter. It just doesn't matter. What you've now got to do is convince people on a jury or a bench officer what you're saying is right. And that's a very different question from what you're presented with day in and day out in the preparation of a case, the various chores like finding an expert such as Steve Franklin to tote up your damages for you, or simply trying to move the ball forward when the defense lawyer might be saying, hey, I don't want this ball to move forward, or when you're the defense lawyer and you're saying, how can I keep that ball from being moved forward? That is all beside you when you get to trial, and all of a sudden the game changes. So what we did here is rather than take turns like three talking heads to talk at you, what we thought we'd do is focus on what actually happens, the mechanical aspects of trial, number one, and number two, show the different perspectives of the judge, a defense lawyer, and a plaintiff's lawyer in a business dispute. So Anton's going to introduce that business dispute to you. If you have the factual scenario, it's very important to read along if you can, because a lot of the things that we're going to talk about is specific to these facts to give you a sense of what it's actually like in trial after that 80% of the chafe has been stripped away and all you've got is a basket of wheat to decide who it belongs to. Anton?
Thank you, John. Read along with me or close your eyes while I read it aloud. Factual scenario for the trial process. A, the parties. Bobo Brothers Dry Cleaners, herein Dry Cleaners, is a limited liability company that operated over 25 dry cleaners outlets throughout Los Angeles County. Evergreen Liquids, Evergreen, is a vendor that sold an environmentally correct, outrageously expensive, and fairly useless cleaning solution. The Evergreen Liquids agreement was entered into 2009 and was approved, amended, acknowledged, or ratified with monthly invoicing and payments by dry cleaners of over $250,000 each month throughout 2009 and 2010. Dry cleaners had a Bank of America brokerage account and 2 Chase checking accounts, each in the Bobo Brothers' name. Pursuant to the Evergreen Liquids agreement, dry cleaners paid Evergreen from one of the 2 checking accounts and occasionally directly from the brokerage account itself. Dry cleaners had a, B, what happened here? Dry cleaners began losing customers as 2009 went on, as they strangely wanted their clothing to be completely clean, the prices charged to be reasonable. Customers proved immune to the environmentally correct themes that Bobo Brothers emphasized in its advertising, branding, and store-front remodeling program. Bobby Bobo saw the writing on the wall, and it spelled disaster. Dry cleaners already had more debts than assets, and so was technically insolvent. He blamed Evergreen and insisted on changing cleaning solutions, slashing prices, and replacing advertising with a coupon program using special pricing and discounts on a rotating basis. Brett Bobo, however, was an ardent environmentalist and refused to change from Evergreen Liquids. Brett's pride of authorship and environmental beliefs in his advertising, branding, and store-front remodeling program drove his brother Bobby Bobo to extreme measures. Between June 1st and 5th, 2010, while Brett was in Sonoma County treating his back pain with medical marijuana, Bobby ripped down store signs, emptied bank accounts, and assigned leasehold interest to a new limited liability company in which he owned 100%. When Brett returned, there were only 10 outlets for Bobo Brothers in the least profitable neighborhoods. On the other 15 outlets, new signs said Bobby's Discount Cleaners, and the leases were in the name of Bobby's new LLC. Brett was dismayed but refused to sue his brother. Angry and upset, he plugged away in the 10 outlets, ever more frequently returning to Sonoma County and back pain relief with his medical marijuana. He was adamant in refusing to sue his brother and willing to settle for a minor sum with Evergreen. Evergreen Liquids was not so complacent. It was owed over $1.5 million, and 6 months' invoices had gone unpaid. When its manager, Angela Brents, that's me, went to Bobby Bobo, Bobby blew him off. When Evergreen's controller called Bank of America and Chase Bank regarding payment of the invoices outstanding, he was informed that the accounts had been closed after a series of transfers, totaling $800,000 in 5 days. Evergreen Liquids did the right thing. They hired no other than Jonathan Stein and said what most clients say to Jonathan: hey, go get those stinking guys. Do whatever it takes. I want justice. And don't charge me for most of your work. Mr. Stein leapt into action, filed a complaint, conducted discovery, and set an early trial date. Jonathan impressed the judicial officer, Judge Joe Hilberman, with blunt and concise arguments of fact and law. Unfortunately, this got nowhere because Bobby's Discount Cleaners had hired Steve Young. Mr. Young blithely stated that Bobo Cleaners had simply run out of money and was the only party liable for the debts. Why wasn't Evergreen suing them? While Mr. Young felt badly for Evergreen, he brought a summary judgment motion demonstrating that Bobby's Discount Cleaners was not a successor interest to Bobo Brothers, and Judge Hilberman granted it. C. Actual or constructive fraudulent transfers are the gravamen of the case. But Mr. Stein wouldn't give up. He focused his case on the Uniform Fraudulent Transfer Act, Cal Civil Code 3439 et sec, EFTA. According to discovery, Bobby Bobo had emptied out a Bank of America brokerage account and the 2 checking accounts in 10 days, paying bills for Bobby's Discount Cleaners in advance. 1 year of rent, 10 months of cleaning fluids, advances to key employees, new advertising, and new signs consumed $800,000 in cash. Bills from Bobo Cleaners totaling $2 million were left unpaid. But every penny of the $800,000 was accounted for and had a business purpose. Under UFTA, the jury would determine whether there was 1, an actual fraudulent intent to delay or hinder creditors of Bobo Brothers, such as Evergreen Liquids, based on the badges of frauds, or 2, constructive fraud based upon objective standards of UFTA for paying money to third parties that failed to provide reasonably equivalent value to Bobo Brothers. The value in this case, of course, was provided to Bobby's Discount Cleaners, a competing organization. Mr. Stein argued that if $800,000 had been paid to help Bobo Brothers, instead of Bobby's Discount Cleaners, there would be no fraudulent transfers in violation of UFTA. However, substantially all of the funds went to benefit Bobby Discount Cleaners, a new LLC with different ownership and no contractual relationship with Evergreen. As a result, Bobo Brothers funds were fraudulently transferred to benefit a new competing organization and to defraud the creditors of the Bobo Brothers, such as Evergreen. A jury trial is set for September 30th, 2011. Special verdicts for the jury would ask to determine 1, if Bobo Brothers and Bobby's Discount Cleaners are indeed separate entities, and 2, whether Bobo Brothers was insolvent from June 1st to June 10th of this year, and 3, whether $600,000 was used for the benefit of Bobo Brothers or Bobby's Discount Cleaner.
Should be 800,000.
Should be 800,000. Please make a correction in your sheet. Thank you very much.
Okay, well, that is the factual scenario. Now, if you'll take the grand finale of civil litigation and just open it one page, you'll see the table of contents. And what we're going to do is take each of the Roman numerals. 1 is motion to eliminate. 2 is jury voir dire. 3, trial briefing. 4, opening statement. 5, arguing jury instructions. 6, arguing special verdict forms. And 7, closing arguments. And starting with motions to eliminate, Steve, what are your thoughts on motion to eliminate?
Well, first I want to acknowledge the very clever and interesting fact pattern was authored by Jonathan. And I also want to do a quick shout out to Raina Richter of my office who helped assemble all these materials. All right, well, motion to eliminate. What are they? Why bother? What they are motions designed to limit what evidence gets admitted and considered. How important are they? In my view, extremely, because they're going to control the outside universe of what the trier of fact is going to consider. What do they accomplish? If they're granted, it prevents evidence from being admitted which might be highly prejudicial or otherwise harmful to your case. And I would refer you to Evidence Code Section 352 as probably the core basis for most of these motions. Highly prejudicial, unduly consumptive of time, or likely to confuse or mislead the jury. But of course there are other grounds too. It also avoids having to raise more objections in front of the jury or move it to strike, all of which take time. And it also avoids having to have sidebar conferences with the judge, and juries are, people are in the box, they're not real happy being left out of the process. They're wondering, what are they talking about? So you want to avoid that as much as you can. And also, because you've done this in advance, assuming you're successful, it avoids drawing attention, perhaps too much attention, to a particular issue, especially so if you make the objection and it's overruled, you move to strike and that's overruled. So it's very important that you do this. And also, providing the appropriate and necessary, not overdoing it, but really focused motions in limine makes a good impression on your trial judge. And that's true even if your case is going to be a bench trial. It allows the judge to see that you have a good grasp of your case, that you're focused on the issues, and it gives you another chance to display your brilliance, which of course you've already established during the law and motion and discovery phases, but you're just reinforcing it. But what it also does, and this is very important, a lot of times you have multiple appearances relatively close to trial. Among other things, you have your final status conference. And you're going to naturally think, well, the judge is going to remember me, he's going to remember my case. I'll let Judge Hilberman speak to that more so, but I don't think you assume anything. I think it's important to always bring the judge back to the key facts, the key issues, and a motion limiting is a great tool to do that. And also, hearing a judge's response in advance of trial gives you some very useful insight into how he or she is thinking about the key issues in the case. And it also gives you a chance to focus the judge on what will be some key issues of evidence. So that's a very, very useful tool. Now, sometimes you may not even have as your true goal getting a ruling at the time you make the motion. Sometimes you know that the judge is going to wait and hear what evidence is going to be offered on the subject. But what it does is it kind of preloads the judge mentally to deal with the issues, because a lot of times what happens is you make an objection, particularly with a jury in the box, the judge has a nanosecond to make a decision. And sometimes these are obvious objections and they should be ruled on pretty quickly, but some of the key issues are more involved, and you want the judge's careful thought on it, not a hip-shoot reaction. Not the judges hip-shoot, but they react quickly because they have to. And you don't have that luxury when you're making an objection, and it's usually the case, particularly with the jury, that the case is moving and you're advancing. There's not going to be a lot of time to backtrack, particularly if the motion goes askew, or your objection doesn't get granted. So having the opportunity to do this in advance is very helpful. And again, it also alerts the judge and gets he or she thinking about key elements of the case that you're presenting. So again, it's very, very important to do. And one of the things that you need to pay attention to is our local rules that really give you in detail, and they're in this materials, the how and when to do this. Now, one of the ones that I will almost always use, and it never gets granted in advance, and I don't intend it to, is in conjunction with cleanup discovery, last round of interrogatories to see if any of the information has changed, last request for production of documents to make sure that you have the universe of potential bits of evidence, is I will make a motion in advance to preclude any document not previously produced. Obviously, until something is introduced, the judge can't rule on that, but you have a chance to alert the judge that you're concerned, you've made every effort to not be surprised or ambushed. So that's something that I would almost always use. Now, why not do it? There are reasons sometimes why not to. One of the things is you might lose, and then you're, in trouble. I mean, if you had a chance to fully brief the issue on a motion limine and you are not successful, you know that you're going to have a problem. On the other hand, knowing that you are, you also have the chance, hopefully, to readjust your thinking and strategy. Also, your opponent might not be quite on the beam, and if you highlight a critical issue, you make he or she think about something that may not have happened had you not made the motion. But I do think that most of the time, the risk of a bad ruling is far less important than the opportunity to gain some very important ground presenting your case by making the motion. Do a good job of briefing it. Really help the judge rule your way. Make sure you have a full explanation, a clear argument on the law, and I think it's a very, very, very key strategy to use when you're going into a trial.
Yeah, but Joe, do you really feel that that's the case if you've got a stack of motions to eliminate, 100 from one side, 35 from another? How do you deal with that?
Usually about a 3-to-1 ratio, I think. I found as a trial judge, and I found it very helpful actually to get the right motions in limine filed by counsel like Steve, who would choose the appropriate motion and the appropriate timing and the topic matter. The primary stated purpose of the use of motions in limine is to preclude the mention of or the attempt to admit evidence that may be prejudicial and where the prejudice may outweigh the probative value. It's a critical issue because the court wants to make sure that it's a fair and impartial jury that hears the case, and we'll talk about that in jury selection concepts, but also that the evidence is presented fairly. If you read the new statute, and we have a new statute here in Los Angeles County in section 3.52 of our local rules, and basically the stated purpose is to preclude the mention of inadmissible evidence. I'm sure all of you have heard the term unring the bell. You cannot unring the bell. And a lot of times lawyers may be prone to ask a question or seek the admission of evidence that they know is inadmissible or extremely prejudicial and won't be received by the court, but they'll do it anyway, knowing that the jury will at least hear the question and maybe the answer, and there will then be a motion to strike. And one of the issues that Steve raised was the granting of an objection. That is helpful, and a motion to strike is always helpful because now the record is clear, but the jury's already heard this evidence. And when they hear a 3 or 4 week trial, and then they go back into the jury room to deliberate, their minds sometimes are confused on what was or was not allowed to be admitted and received by the jury. And they've heard it, and they may have kind of forgotten which part of the testimony that was presented to them they were not supposed to consider. And so that stricken evidence may become part of their thought process. So by utilizing the mechanism of a motion in limine, you preclude the opportunity for one side to try to introduce this evidence, which would then be inadmissible. Also, in terms of the tactical approach, judges really want to help the case move along at a proper and appropriate pace. And if the parties are clear at the outset what is or is not going to be received by the court, then they can really craft the presentation of evidence to go within those guidelines. Of your question, we've all seen cases, I'm sure you would never do it, Jonathan, where one side or the other will just file motions in limine on every issue in the case. That's an abuse of the process. The purpose is to craft the presentation of evidence. It's not about making decisions as to the total outcome of the case, but rather just to guide the court in the proper presentation of evidence. Many of you have been in litigation where the other side serves what we call boilerplate motions in limine, and they serve the same 27 motions in limine in every case. Like really critical issues like the court should only consider admissible evidence, grant, deny. No, we're going to hear everything, and we'll let it all in. That's a waste of everybody's time. And as a practical note, judges hate that stuff. Particularly now, and this is my pitch for all of you who are litigators to help your court, they're understaffed, and they don't have the resources to really spend the time that would be necessary to review 100 motions in limine. So pick the ones that are really significant, and follow the new guidelines as set forth in these outstanding materials. My congratulations to you and your firm, Steve, in putting this together. But it's cited there as the motions in limine 3.57 of our local rules just adopted this year. And use those as guidelines, comply with the court, the rules, and only choose those items which are really critical to the presentation of evidence.
So, Joe, tell us a little bit about voir dire. What are the basic ground rules to guide the questioning of a jury?
So let's back up a moment. Putting this in context, as Jonathan said, by using the table of contents, what's really been done by the panel, and to Jonathan's credit, I think the outline itself, is kind of the timeline of how things are done. You've already done the pretrial stuff, as Jonathan said, and as I'm sure you would agree with him, a vast majority of the pretrial materials, the discovery, the depositions, the interrogatories, the voluminous document reviews that you've done are really not going to be very significant at trial, but you need to do that to be fully prepared. Now you're at trial. So you meet with the court in your pretrial presentation, and you meet with the judge and talk about what will or will not be motions in limine and what will or will not be the evidence. You talk about who the witnesses are going to be, you've got an exhibit list, witness list, and you filed your trial brief, which I encourage all of you to do in every case. Let me say that again, all of you to do in every case, and that includes arbitrations and court trials. And then you come in and you're now going to select the jury. Well, the purpose of voir dire, or voir dire, depending on where you went to law school. How many of you learned voir dire? How many of you learned voir dire? How many of you didn't learn it at all? I think the Latin is translated loosely as to speak the truth. And the purpose of voir dire is to select a fair and impartial jury. That's the purpose. It's not to be used to prejudice the jury. It's not to be used to prejudice the trier of fact in any way or to get out facts that may be relevant to your case. It's a procedure where each side has an opportunity to ask questions to determine the fair and impartial nature of the prospective jurors. And it's that simple. But judges are going to be very concerned with questions that are designed to prejudice the jury or to present what may be the evidence in this case, because that's not the purpose.
Well, that's good to hear from a judge, and it's completely wrong. It follows the law, but that's not what voir dire is about. So let me show you what I think voir dire is about. Now remember, he's been on the bench. He's had 100 trials. But this is one take on voir dire, and it's one that I think you'll find is sincere. Anton, you're going to be the juror, okay? And now I'm going to ask you, you haven't heard any of these questions before, right?
Not at all.
And I actually haven't had much chance to prepare them, but I'd like to ask you some questions as a juror. What is your name?
Well, before you do that, I'm going to cite you for contempt of panelists.
Anton Lebrentz.
Anton, and what do you do?
I'm a lawyer most of the time.
And you a member of a firm?
Yes, I am.
And what firm is that?
Law office of Anton Lebrentz.
Okay, so you're your own little small business, right?
I am, yes.
Okay, now who do you earn money from?
Other attorneys.
Other attorneys. Any firm in particular?
I've done contract work for Melvin Myers.
Oh, Melvin and Myers. Okay, and every time you go in to give them your bill, you get paid?
Yes, sir.
More or less. Maybe they say not quite so much in this, or maybe you did a great job on that. But you get paid. Now, have you ever gone into O'Melveny Myers and been told, I'm sorry, we're not O'Melveny Myers anymore, we're simply Myers?
Not that I recall. No.
Okay. Now, if you did go in and they said that to you, what do you think would be your response?
I'd still expect my payment.
Well, what happens if he says, what would you do? I mean, we have to find out if you're going to be a fair juror here, but what would you do if you went into O'Melveny and Myers and say, well, we're simply Myers, that bill is going to be paid by Mr. O'Melveny? What would you do?
I'd probably search out Mr. O'Melveny, but I want to get paid.
Now, and do you think that would be fair if they said to you that you did all your work and you present your bill and they changed their name and now the guy without the name? Do you think that's fair?
I don't think that's fair.
Okay. Now, do you believe in minimum standards?
Absolutely.
Yeah, it's part of a free society, isn't it?
Definitely.
Okay, so you have a driver's license, right?
I do.
And when was the last time you renewed that license?
A few years ago.
Pretty easy to do, right?
As long as you do it online and not at the DMV.
Okay, but even at the DMV, they check you off for some pretty minimal things, like can you see, right? Now, do you think it's fair that the government say, hey, we have a minimum standard here that we want drivers to be able to see?
Sure, it's in everyone's benefit.
Okay, so you feel that that's a fair minimum standard?
Yes.
Okay, now and a diploma. Did you earn a diploma in high school?
I did.
Oh, you're a well-educated guy. I mean, high school and college too, right?
I believe so.
And then law school.
Yes.
Okay, so you're a great believer that would it be fair to say that you're a believer that diplomas represent that minimum standard, that when somebody comes to you, They know you graduated high school. They know you graduated college. Is that right?
I'd say it sets a general competency, yes.
And did you pass the bar exam?
I did.
That's great to hear. You know, it's really hard to pass those things. Now, I want to say, like, only half the people do, right?
I think that's right.
Yeah. Okay. So, but doesn't that tell people that use you that you've passed a minimum standard, and you know at least a minimum of what you're supposed to know when advising them?
Yes.
Okay. Now, do you feel as a juror that if that the judge instructed you on what the minimum standards are for a business and how it treats its creditors, do you feel that you could enforce that?
I believe so. I could apply that.
And you feel you could understand that in this minimum standards might be that if a creditor's owed money, that it has to be paid?
That sounds reasonable.
And that actually might even jive in your own experience of wanting to be paid yourself.
That's correct.
Well, that's great. Now you use dry cleaners, haven't you?
I do.
Any emotional reaction? You ever get mad at your dry cleaners?
Occasionally, but most of the time they do a good job.
Did you pay them even if you were mad at them?
I did, because they still did the service.
Okay, so you believe in paying your bills, even if it's dry cleaners.
Yes.
No more questions.
Thank you.
Well, I don't know. For the defense side, I hear an awful lot of preload of the jury. Is this fair? How would you feel if you weren't paid for your services? I would find that pretty troubling. One thing I do want to say, and here's the problem that happens, is when a lawyer is conducting voir dire, it's really difficult to interrupt that, even if it's going way, way, way beyond what it should. Jonathan didn't go too far, a little bit, but at least in my view. But you really can't interrupt. I mean, there's a difficult problem there in terms of maintaining courtroom decorum and not interfering with a right to examine a juror, because you do have challenges for cause as well as peremptories, and you're never going to know if there's a challenge for cause unless there is a reasonable examination of the prospective juror. But at some point it gets to be way too much. And Judge Hilberman, you've seen abuses of that process, and what do you do and what do you suggest that the attorneys do if they feel that their opposing counsel is just way, way, way beyond and it's clearly trying to preload and prejudice the jury?
Well, I agree with you. I think that it is difficult to interfere with the flow of voir dire. And sometimes you want to know what those answers are too, so you're going to let opposing counsel go ahead and ask some questions that you might ordinarily not want to hear, on the hope that maybe this person is going to give you the answer that makes you believe and understand that that is not a juror that you want on your jury panel. Not everyone is going to be as stellar a juror as Anton, but you want to know whether they're going to be that stellar juror. The same issue that Steve raises in terms of an unwillingness to interrupt voir dire because it breaks the rhythm, it shows that you're kind of obstructionist, is one of the issues that you confront when you make a decision whether or not to object to a question during testimony. Because juries sometimes think that you're trying to hide something from them. Why aren't they asking that question? Which, by the way, falls back onto the prior subject of getting the stuff taken care of in limine,
Exactly.
so that you don't have to raise those objections in front of the jury, so they don't have to wonder what it is that you're trying to hide from them.
Because they know it's something.
It must be something, otherwise you wouldn't have objected. I once had, when I was a trial lawyer for the 27 wonderful years before I became a judge, I objected on the grounds that it was irrelevant. And the judge said to me, it may be, Mr. Hilberman, that you're right, but I'm curious, so I'm going to let it in, which is the curiosity exception to the...
You won't find that in the code.
No, and the jury found it in their hearts to think that was really important. But that's a different story. I think that the questioning that Jonathan did actually, although Steve suggests, and I think he's right, that it was getting close to the edge, I think it was fine. I think it was incisive, you were kind of interested in the answers, but you were mostly interested in letting the other people in the jury box know that this is what the case is about and what a thoughtful person this guy is, because he pays his bills and he's responsible and he's thoughtful, which is really what the purpose was. He couldn't care less whether he stays on the jury, but he's done a very good job within, I think, the bounds of questioning to not go over that line to the point where Steve just can't stand it anymore and would stand up and object.
And if I can mention one thing about what I did is you saw the themes of fraudulent conveyance. What is fraudulent conveyance? It's a minimum standard that the government set. Now, am I asking him about fraudulent conveyances? Am I trying to cite the law? this guy would be down my throat in a second. No, you have to find a way to examine the themes, and this is where the art of a lawyer takes place. It's what we all signed up for when we became lawyers, and what we never do day in and day out nearly enough. And that is to focus on the truths behind the words. What are the societal conflicts going on behind the conflicts of our clients? What can we do to package those conflicts in a way that's modern? We live in a time where I call it the no BS time. People are intolerant with a 24-hour news cycle for the shenanigans that when we were growing up used to be taken as they were fine. There's an intolerance for hiding the truth now, far more than 25 years ago, I think, and a desire to get to the truth in a manner. So what did I focus on? I focused on the everyday life of what happens when you're the guy presenting the bill, number one. And number two, what does the government do in terms that we all agree on? Republican or Democrat, Tea Party or liberal leftist, whatever it is, you still agree that minimum standards need to be there to create a civilization. And that's what I'm trying to focus on, because when we get to the jury instructions, you'll see in the jury instructions those same themes jump off the page. But before we get there, we have the trial briefing. Now, Steve, you're a man of the pen. What do you try to achieve in a trial brief that comes after the motions in limine have been decided, after the jury has been picked? You may have written it before, but at this point you submit your trial brief.
First of all, as Judge Hilberman said, I think it's extremely important to use a trial brief, even in cases that are going to be a jury trial, because you're going to inform the judge, who is going to be calling the balls and strikes and making some critical decisions of law, quite likely, what the case is about, and to make sure that he is going to track, or she is going to track, along with the presentation of the evidence, so when it's time to make those objections or motions to strike or have those sidebar conferences if it's unavoidable, the judge is well prepared to rule. What you want to do, and it's always a balance between how much do you reveal, because if you're going to do a trial brief, then you have to serve the other side. So it's kind of a balance between how much you really reveal and what you hold back. But you certainly want to inform the judge what your main themes are, your key witnesses, the key documents that are going to be admitted. By this time, as Judge Hilberman said, you've already exchanged your documents. You already know who the witnesses are. And you might as well put your best foot forward. Again, that doesn't mean you don't hold a card or two in your back pocket, but you try to show enough so that it's very clear what the case is all about. Now, if it's a bench trial, absolutely imperative that you do a very, very thorough job of briefing, including any evidentiary issues. If you decide not to use a motion to eliminate, another way to go about it is through the trial brief, and also that you highlight any testimony that is anticipated based upon depositions where you're going to likely see some attempt to weasel out of what's been said in a deposition, or an effort to contradict a document, to go contrary to the terms of a contract if you're suing on a contract. Things of that nature are really important. I can't stress the importance of a well-written trial brief enough. And again, you want to make it as easy as you can make it for the judge to follow along, to rule your way if there's motions to be made or objections to be made, and fully understand the case. And if the judge is ultimately your trier of fact, to absolutely give you judgment in your favor, and you start as early as you can, and nothing does it better and more completely than a thorough, incisive trial brief. That's my view of things.
So, Joe, what was the last time you read a thorough and a decisive trial brief?
What's today? It varies. I mean, the quality of trial briefs vary. What's striking to me is in my new practice, which is in this mediation, arbitration, discovery referee world, is how seldom people file outstanding trial briefs in arbitrations. Arbitration, I see that as just like a court trial. It's the same thing as a court trial. And even if we have two-party arbitrators and I'm the neutral, it's going to be 2-1. It always is. And so you're really selling it to the trial judge. So when you're in a court trial, it's really essential because that judge is the trier of fact and will be applying the law, as opposed to when you're in a jury trial where it's the responsibility of the jurors to apply the law. But still, the judge is going to make the calls on what is or is not admissible and what will or will not be the jury instructions, and we'll get to that in a few moments. Some lawyers write beautifully, and some don't write quite so beautifully. Some lawyers write way too much, and I think part of the recurring theme that you'll hear from me tonight is that judges have a finite amount of time. And so you need to be concise, you need to be accurate, you need to be thoughtful, and you need to be thorough enough to get across exactly what you want the judge to understand. But realize that they're not going to have the luxury of time as judges used to in the past, and hopefully will again have in the future, because they're pressed for time. So make it appropriate, make it concise, make it meaningful, and make it persuasive. One thing I do want to say is, as Steve suggested, the role of the judge is to get it right. And the role of the attorney is to provide the judge with the information, the facts, and the law that he or she needs to make the right decision. That's your job. Now, the evidence is going to come in during the trial, but you're going to utilize the instrumentality of the trial brief to give the judge a heads up on the applicable law and what the evidence will show. And then when the judge reads it from both sides, he or she will then have the opportunity to anticipate the forthcoming evidence and offers of proof and really be prepared to thoughtfully consider those facts and apply them to the law that you cited. Because every judge I know really wants to do the right thing. And they don't want to make your life more uncomfortable or more difficult, because being a trial lawyer is a very difficult job. But being a judge is a tough job too, and your job is to make the decision-making more clear and easier for the trial court. The most important thing is never misrepresent anything to the court.
And the one way to do that is in a trial brief, get it down to the basics. Most judges, Joe's a bright guy, there are a lot of bright judges, but a lot of judges are picked because they got great personalities and they're not so heavy in the brain department. Now, the problem with the business cases, that works well in criminal, that works well in courts. It doesn't work so well in business where
Jonathan,
there
this
are
is being
these questions.
recorded, you know.
Right. So what you do in a trial brief is you appeal to that judge. You've gotten to know him in Law in Motion. You've seen him in the final status conference. He's ruled on your motions to eliminate. You've seen how he's handled the jury, whether he's a personality guy or a brain guy or a little bit of both. And now you're writing a brief to that guy. It is the most personal Christmas card that you've ever sent.
May it please the dummy? Is that the way you're going to start this?
May it please the guy that has my future in his tender little hands is how I usually write them.
Better still.
But what I try to do is I try to really get down to basics of saying, why is this guy that I'm trying to sue liable? Or why is my guy not liable? And I'm trying to convince that one guy of it. And it's very different from what you learn in law school. So now that we've talked about the trial brief and the voir dire and the motion to eliminate, we have the opening statement. And this is where the fireworks start. So we're going to ask Steve to stand and deliver his side of
Plaintiff
why...
goes first.
Well, I thought that we just listen to yours. Or you want me to go first? You want to come off?
Yeah, but I just want to point out, in the materials, there's a couple of sample briefs, so you get to see if I'm any good as a writer or no, just to give you an idea, in a sense. And those were briefs from 2 trials that I've done within the last year. So you get a sense of maybe how to write it right, or maybe wrong, but we've got the samples.
Okay. So what I'll do is I'll be very brief, and I'll have Steve. You'll spend a little bit longer on your opening statement, right?
Probably because I need to.
Oh, okay. Well, ladies and gentlemen of the jury, the evidence will show today that Evergreen Liquids, who I represent, supplied cleaning fluids for dry cleaners. That was Bobo Dry Cleaners. They did it under a contract in 2009. This contract was approved, as the evidence will show, it was amended, it was ratified, it was confirmed with monthly invoices, and the evidence will show that for month after month, year after year, these invoices were paid about $250,000 each. Thereafter, the evidence will show that there was a problem at Bobo Cleaners that had nothing to do with Evergreen's bills and whether they were right or wrong. Now, you may find in this evidence that Evergreen Cleaners may have been better or worse in their cleaning fluid, but you will also find in this evidence that their invoices were never questioned and that this debt existed. Well, what happened then, the evidence will show, is that the Bobo Cleaners went out of business one day, and the next day it was Bobby's Discount Cleaners. Now, businesses change all the time, but you're here to look at this one instance. And we think the evidence will show that the money from Bobo Cleaners, that money that was needed to pay creditors such as Evergreen, that money was used to finance Bobby's Discount Cleaners. At the end of the case, you'll see jury instructions that will tell you the minimum standards that businesses have to adhere to in paying creditors, and we think that you'll find the evidence presented in the next several days and perhaps a week, that evidence shows that money was taken out of Bobo Cleaners, used to finance this new company, and not to pay the creditors of the old company. And we hope that you'll find that that was against the laws of California as expressed in the Uniform Fraudulent Transfer Act. Thank you.
I want to make an observation about technique. What you saw is an excellent opening statement. Mr. Stein got up there and he told you his view of the case in a very brief fashion. He did it without notes, and he had it very clear in his mind as to what he wanted to say. I use a slightly different technique. And my objective is to make sure that I cover everything that's important. So, knowing my own limitations, I rely extensively on notes. I spend a lot of time preparing my opening statement and my closing arguments. I rehearse them and I time them. I know them pretty well, but I'm not going to take the chance that I'm going to forget to say something that might be important. So I just wanted to make that technique observation, and that's not in any way a criticism of how Jonathan did it. It's just to show you a contrasting style. Ordinarily, when I give my opening statement, my closing argument, I use a podium so I can prop up my notes. So I'm not going to stand as Jonathan did. I'm going to simply work off my notes, and forgive me for that anyhow. So I'm going to pretend you are now...
Let me ask you a question.
Sure.
Do you tell the jury that when you stand up?
No.
No. Why not?
That's what I'm doing?
Yeah. Ladies and gentlemen, I hope I don't offend you. I'm going to be reading from my notes because this is very important and I just don't want to miss it.
I don't do it on opening, but I do it on closing, and I'll tell them exactly why, which is, we're going to come back, we're going to look at the evidence, and I want to make sure that I don't miss highlighting for you the important things that you've seen and heard during the course of the testimony. So I do it then, I don't apologize or explain it on open, but I do.
He also believes that by looking at these notes, having made that presentation before his closing argument, that they'll believe that actually was the evidence and he wrote it down instead of just the stuff that he's made up.
Exactly. I'm found out, Joe. Got me. Okay. So now you are all my jury. Okay? So I begin. Good evening, ladies and gentlemen. As you know, I'm Steve Young, and I represent Bobby's Discount Cleaners, LLC, which is the defendant. Sometimes I'll refer to that entity as Bobby's. This is the first of only 2 times I get to speak to you directly, as opposed to Mr. Stein, who gets to speak to you 2 more times. And there's a reason for that. The reason is because it is Mr. Stein's client, Evergreen Liquids, that has the burden of proof in this case. As the judge will explain to you, that means that his client must prove that it is entitled to recover money from my client, as opposed to my client having to disprove that it owes money to Mr. Stein's client. Now, you've just heard Mr. Stein give his opening statement. He has told you what he expects that the evidence will show. I rather think of it as what he hopes the evidence will show, because as you might expect, my view of what the evidence will show is rather different. Well, we can certainly understand the desire of plaintiff Evergreen to be paid for the merchandise that they supplied. But what the evidence is going to show is that the cleaning solution was ordered by and supplied to Bobo Brothers Dry Cleaners. Evergreen's invoices had always been paid by that entity, and that is where the responsibility may ultimately lie. But the evidence is also going to establish that my client, again, Bobby's Discount Cleaners, never ordered this solution, which, while environmentally correct, ridiculously expensive, pretty ineffective. And as the evidence will show, my client, that is Bobby's, prides itself in actually offering good service, meaning the clothes actually come out clean and at affordable prices, not prices that are overly inflated because it has to buy this ridiculously expensive and ineffective cleaning solution. Now, as you listen to the evidence, I'm going to ask you to ask yourself, why is it that Evergreen Liquids chose to go after my client, Bobby's Discount Cleaners, a company that never ordered this cleaning solution, never received these materials, but rather Bobo Brothers did, and Bobo Brothers is not here as a defendant. Mr. Stein is pursuing the claim against Bobby's based on a theory of fraudulent transfer, based upon the fact that Bobby and his brother simply divided certain assets of Bobo Brothers Cleaners. And by the way, Brett continued to run, that is his brother, Bobby's brother, continued to run Bobo Brothers. Now, as the evidence will be presented, what will be equally important to what is presented to you is what is not presented to you. In fact, focus on, as the evidence comes in, if you see anything that shows that Bobby's ordered this material, that Bobby's ever got this cleaning solution, or that Bobby's ever paid for it in the past. In fact, Bobby's didn't even exist when this cleaning solution was ordered and delivered to Bobo Brothers. At the end of the evidence, both Mr. Stein and I will both have a chance to address you directly. One more time for me, twice for Mr. Stein, because again, it is his client that has a burden of proving to you my client is responsible for payment to his client. After closing argument, the judge will instruct you on the law that is to be applied to the evidence, and we're confident that when you apply the law to the evidence, you will conclude that there is simply no factual basis for imposing liability against my client. Thank you.
So here's my observation about these opening statements. They weren't argumentative, they were very factual, and this is interesting. When we had a little meeting a couple weeks ago to talk about how to present this, we had this rather complicated fact situation, a complex area of the law. And each of these fellows decided that they would impose a 3-minute limitation on their opening statement. I think that those were two of the best opening statements I've heard, because they were only 3 minutes. They told you everything you really need to know. They didn't go through every document you would hear, every witness you would hear from, or why each part of the case would be significant to the next, but rather they gave you the overarching theme that each of them wanted to say. And I think putting this artificial 3-minute limitation forced them to focus really hard on what is really important in this case and how will I explain to the jury what to look for. I just want to make a couple of observations. First of all, the time was spectacular, because oftentimes many of you have seen you would never do this, but other people in their opening statement really go into such excruciating detail that everyone's tired of hearing about the case before it even starts. You don't want that to be your client. Steve pointed out that in his presentation that he's really talking about the things that aren't going to be proved in this case. So suddenly there's a question in the jury's mind about what this is really going to show anyway. What are we going to hear, and why aren't we going to hear this other stuff? And I guess if we don't hear it, he must be right. On the other hand, if they hear this stuff, your client must be entitled to some substantial amount of money. There are only two other observations I'd like to make, and that is choosing the simplicity of words. Studies have been done by people who I read about who say that the average intelligence level of a juror is about 8th grade. And I don't know if that's still true, but that's what I had always believed when I was presenting evidence as a lawyer. You have to be very careful in your selection of words. You have to be careful about using words like thereafter, or the entity. Jurors don't get that. You can say later or after that, or you can say the business. And once I heard a jury consultant say that the two most difficult words to ever use in front of a jury are prior and subsequent, because they don't quite know what those mean. You say before or after. And this is a complicated fact situation. Each of these guys took it, synthesized it down, and gave really good, compelling opening statements that make this sound like a pretty interesting case. And I guess that's the last point. What you really want to do is have the jury interested in your case, because they did not come there because they wanted to. They came there because there was a summons to appear. And so your job as the trial lawyer is to engage them. And I think both of them really did that.
Okay, so now let's argue jury instructions, right? You've heard an opening statement. You're going through trial, you're taking your witnesses, and every once in a while you'll see in trial the judge will say, well, ladies and gentlemen, jurors, this lady can't avoid picking up her kid today. Someone else is sick in her family, so she has to leave at 1:30. Why don't we all knock it off at 1:30? And lawyers, why don't you stick around and let's start piling through our jury instructions. And to give you an idea of what happens after the juror leaves, and at 1:30 you come back to lunch and there's the judge and the clerk and the court reporter and yourselves, you're going to go through the jury instructions. And we've got one of them for fraudulent conveyance that Steve's firm found. It's about 10 pages from the end. And let's take a second and find it. This is a very different part of the program. It's 4,200 actual intent to defraud a creditor. And if you get to proposed verdict forms, you're too far, and there should be a proof of service and a brief right in front of it. So, right. So, everybody got it? Yes, no, maybe? Raise your hand if you don't have it. One doesn't have it. Maybe you can look over on your friends. Okay. So Joe, walk us through first of all, what are we looking at? 4,200 actual intent to defraud a creditor.
Well, if the question is, what are we doing with these instructions during the conference? Well, let me back up and just say one other thing. I love to carry around and cite the Los Angeles County Court rules. For those of you who are litigators, and I presume all of you are or will be, Chapters 7 and 8 of the Los Angeles Superior Court rules tell you every rule you need to know about pretrial in Chapter 7, and in Chapter 8, trial procedures in the County of Los Angeles. And it's really striking how few people take the time to just read through them. I think the total must be 20 pages. Read them, know them, and then you will be the darling of the trial court, because judges love it when you actually know the rules. Can you imagine? Actually knowing the rules. So, it says in the book that you're supposed to have a conference to discuss jury instructions. And as you know, there's a primary source of information, which are the new Casey instructions, which used to be the Badge instructions. And what you're going to do is select those Casey instructions which comport to the evidence and the facts and the law in your case, and then present them as modified to the trial judge, and you have this conference, during which time the proposing side argues that these are the appropriate instructions, and the opposing side says, no, I don't think it's applicable, and the judge has to make the call. One of the things Jonathan said was the court reporter's there, because this is part of your record on appeal. If you request a particular jury instruction and the court denies it and does not give that instruction, and the Court of Appeal later looks at it, you need to have a record that shows that you requested it and they denied it and you argued it, and then you have an appellate issue. Beyond that, I think that the instructions are pretty self-explanatory. More difficult are the circumstances where you don't have a formal instruction and you have to get into special instructions.
Right. Now, remember from our fact scenario here, there's actual fraudulent intent and constructive fraudulent intent. Constructive fraud. This jury instruction deals with actual fraudulent intent, and you've listened to us long enough, so we're going to go around the table, so you'll know what turn it is when the person next to you is already gone, and we're going to fill in the blanks. Very simple thing to do, except when you get into it and you begin to try to piece it together. So, point number 1, actual intent to defraud a creditor. Anton, how does that start? The name of plaintiff is what?
Here it would be Bobo Brothers Dry Cleaners.
Is that the plaintiff?
I'm sorry, Evergreen Liquids.
Okay, so Evergreen Liquids is the name of the plaintiff. Evergreen Liquids claims it was harmed because... Name of the debtor? Sir?
Bobby Brothers, I think it was.
Right. No. Bobo Brothers.
No, but he said, oh, I thought you said that they weren't named as the defendant. I'm confused.
Well, the name of the debtor would be...
Oh, I thought the defendant, you're talking about the debtor, okay.
Right, so this is on the first line.
Yeah, okay.
So Evergreen, the plaintiff, claims it was harmed because who fraudulently transferred property?
I see, okay. Evergreen, Bobo Brothers
Fraudulently, exactly right.
transferred to Bobby Brothers.
Okay, so here we are. So the first line now is reading, Evergreen claims it was harmed because Bobo Brothers fraudulently, and then, ma'am, next in line,
Bobbies. Two Bobbies.
Well, no, you have to choose transferred property or incurred an obligation.
Incurred an obligation.
No, transferred...
Transferred property to Bobbies.
Yeah, now what's the case about? It's about the transfer of $800,000 from Bobo Brothers to Bobby's. Okay, so it's transferred property?
No?
Okay, so it's transferred property to name of defendant? Sir, that would be who?
Bobo Brothers.
Bobby's.
I'm sorry, Bobby. Yep.
Okay, now are you beginning to see why you have conferences about this stuff?
Right.
I mean, here we have trained practitioners, you've been listening intently, and in fact, you have to get this stuff straight, so the court reporter is taking it down, but in fact, what does arguing jury instructions really mean? It means getting this right. It's not easy. Okay, so now we're transferring property to Bobby's Cleaners in order to avoid paying a debt to, name a plaintiff, ma'am? Oh, no, sir. I'm sorry, I didn't see you in there.
That's okay. The plaintiff here is Evergreen, if I'm not mistaken.
Okay, so we have now Evergreen claims it was harmed because Bobo Brothers fraudulently transferred property to Bobby's Dry Cleaners in order to avoid paying a debt to Evergreen. Okay, everybody got that first sentence? A lot more sentences to go, right? And you see what goes on then. This is called...
If I might, Jonathan, a quick
Please.
observation. Now, what actually happens is you go through this exercise in your office. You prepare these instructions and you fill in these blanks, hopefully correctly, and you then submit them and exchange them with the other side. They're doing the same thing. And what typically happens is there are instructions that match, usually the very basics. There are key instructions that may be filled in differently, that may be modified, maybe specials, but these all come into the judge and are served in opposing counsel before you have this conference. So actually the exercise we're going through is illustrative of what you have to do in your office. This actually does not happen during the conference.
Good point.
It shouldn't.
But you've had some strange
What actually
experiences.
happens is if you were in Department P up until about 3 years ago, you would have been ordered to exchange your jury instructions and then to meet and confer outside the presence of the court before you came to our little conference, and then you would have been instructed that when the court takes the bench, because you got to call myself the court, takes the bench, I want to see 3 piles. I want to see the big agreed to pile, and I want to see the 2 little piles, which are the ones the plaintiff wants and the defendant doesn't want, and the ones the defendant wants and the plaintiff doesn't want. And then we just whip through the big agreed to pile, and then spend our time deciding the other ones. And that's why, in terms of if I can put in care and feeding of judges for a moment, I've already talked about the lack of resources, et cetera, and time. The easier you make it for the judge, the better the whole case goes. And so if you can cooperate with opposing counsel on as many things as possible, especially those things that are pretty easy, like just agreeing to agree or agreeing to disagree, how hard can that be? Then you just get the big pile of the agreed to ones, and then you argue the other ones. And that's the judge's rule then, is to make a determination of what is or is not going to be given to the jury. You make your record. You may not be happy with it, but that's what you've got to deal with.
Let me ask you a question.
Okay.
How important, if you are coming up with not a standard instruction, it's not a Casey, it's not a Badgie, but it's a custom instruction that you think more appropriately fits the issue to be decided or the issues to be decided, what do you need from counsel who's presenting that, would be a special instruction, in order for you to decide, is this the instruction I should give or should it be rejected?
That's a good question. Special instructions are difficult for the court because courts prefer to have standard instructions. It makes life easier. But some cases require special instructions, like this case.
Yeah, let's stop for half a second and look at what he's talking about. You saw right here, actual fraudulent intent. What you've got is the only khaki instruction here. It's on actual fraudulent intent. Statute, however, also has constructive fraud to be proven based on objective standards for paying money to a third party that failed to provide reasonably equivalent value. Okay? So when he's talking about special instructions, we're here right now. You got two different ways to hang them up. One has an instruction and one doesn't.
Exactly.
So what do? You go to the code and you say, what is it in the code that tells me how to draft a special instruction? And it requires you to have a statement of the law. And then it has to, under that statement of the law, in a portion that can be cut off because the jury's not going to get that part, has to be the foundation for that, the authority for that. And it's either going to be a statute or a series of cases that will then cite the judge to the supporting foundational law upon which the judge can then rule whether or not it is an honest and true statement of the law. And once the judge makes that determination that it is a factual and accurate statement of the law, then the judge must decide whether that statement of the law applies to these facts. And if so, the judge will probably give the instruction. If not, it'll be declined.
Okay, so that sets us up for the grand finale, and that is closing arguments. Well, actually, before we get there, though, there's another thing. After the jury instructions, what do you have? You have special verdict forms. Steve, what do you do with yours?
Okay, well, these are going to be probably the most key documents that the jury is going to have in its hand as it retires to deliberate. These are the questions that will need to be answered by the jury, yes, no, as you have them processed through the claims. Every claim, every cause of action has key instructions on the elements that must be determined in order to find liability or in order to establish a defense. And so if there is anything that's critical, as between a jury instruction and the verdict form, to me, the verdict form is the most critical because literally those are the questions and the answers which are going to result in a verdict. And what happens is, if you've ever seen a trial and there's a long litany, multiple causes of action, the judge does his or her level best to read it with interest and verve, but inevitably the jurors grow tired of listening and they start to glaze over. I mean, it's just inherent in, I think, being a human being. There's only so much information you can absorb at a given time, but the judge is required to read a stack of instructions that thick. And so part of the way through, and Judge Hilberman can perhaps elaborate on that, you will start to lose focus, you'll start to lose attention, and they may not hear or understand some of the instructions, but what they will have in their hand, what they must process through, is those verdict forms. Absolutely critical. And you're going to see how important it is a little bit later when we do closing arguments. That would be my observation.
For me, a special verdict form is whether you get the money or not. And the other thing is whether you survive an appeal or not. What you run into in the special custom verdict forms is the chance for all your work to go down the drain. If all your work has gone down the drain, you have to do another trial. Steve's going to come up to you and say, gee, John, you did a great job. No doubt you could beat us again, and I'll give you 10% of what you could earn. And I'll sit back and say, you know something? That's a pretty generous offer given the circumstance.
I reduce it to 5.
And this is the problem.
7.5.
This is the problem. Do you really have the economics to do it again if you screwed up a single jury instruction that was important enough? Now, there's harmless error, of course, and Joe can tell us the difference between those two. Or, number two, whether you fail to get a special verdict form such that an appellate court can say, well, yeah, they may have made a mistake or two, but look at this verdict form. Was he fraudulently conveyed, yes or no? Gee, that's a pretty clear answer. Here's the evidence. There's enough evidence to get to that answer. I'll just excuse all the rest of the errors. So that, to me, the special verdict form is your lifeline should you get appealed. And that lifeline will uphold your settlement value if you've successfully conducted the right trial.
Joe, what do you think about how important the verdict forms are?
I was just thinking about the verdict forms in conjunction with the instructions. We're going to hear a closing argument. Just, ladies and gentlemen, you're soon going to hear a closing argument. I'll remind you, closing argument is not evidence, and that's what the jury's going to hear. And so they're going to kind of listen, but they've already been told it's not evidence, and they're reminded that you have heard all the evidence, etc. I think that in conjunction with the jury instructions, the special verdict really kind of forms the anchor of who gets the case after it's all over, whether you get the money or you don't. And I think what we'll see is that really skilled lawyers will know what the instructions are, and the jury will have just heard those, because most judges, I think, today pre-instruct. And I think and if you're trying a case, I would ask the judge to pre-instruct, because then the jury hears the closing argument. For those of you who hadn't had a jury trial, pre-instruct means they hear the jury instructions before the closing arguments of the lawyers. Traditionally, the lawyers would argue, then the jury would hear the instructions, then they would go out and deliberate. I think more commonly now, is that your experience?
I think it's about 50-50.
Well, I used to pre-instruct because you read the jury instructions first, so then the lawyers can argue, and instead of having them say, the judge will tell you, they can say, as you've heard, the law in this case is, and then they're going to argue to the jury instructions. And they're going to point out to the jury why the evidence that they've heard is consistent with what the law is, as the judge just advised them. And then they're going to turn to the wonderful blow-up of a special verdict form that they'll have on the wall on the Elmo machine, and they'll go through it point by point and explain to the jury why the evidence they just heard shows that the defendant was fraudulently conveying this material, and the plaintiff is entitled. And ladies and gentlemen, when you get to the first question, the answer is yes. And they'll go through it. Steve might say no.
You might
but we know
expect that I will.
Jonathan's going to say yes. And I think that one of the great advantages of a jury form is it forms an outline for your closing argument, that you argue to the jury instructions and the jury form, so that when the jury goes back into that room to deliberate, they now have a template of what the answers ought to be, and you've already told them how to fill it out.
And with that in mind, closing argument. And the plaintiff goes first, then the defendant. What I'm going to do in my closing argument, ladies and gentlemen of the jury, is try to pull together evidence. Now remember, what I have to say is not evidence, but hopefully it'll help guide you in your deliberations, because what we're all looking for, my colleague Mr. Young, the judge, and myself, is the truth and fairness. And what we're looking for, especially, is that the minimum standards of law be upheld. Business is not a jungle. It may be called dog eat dog, but we know better. And you have heard the jury instructions, especially Section 4200. It calls for the taming of the law of the jungle. It calls for the application of minimum standards. So to answer a question that you heard before, not from me, but from Mr. Young, Mr. Young challenged you and said, why go after Bobby's discount cleaners? What's not being said here? Well, what's not being said here is the law that you just got instructed on. You now have in front of you what was not said for the evidence. It is the law that makes us different from countries like Libya, makes us different from societies like the Civil War, where they were arguing about basic issues of slavery that we would take for granted. We now argue about higher standards, minimum fairness to people, minimum fairness that makes business go. Because how can Evergreen Cleaners provide month after month of services unless it feels it'll get paid And if it can't get paid, at least there's a legal reason it can't get paid. What you saw in this evidence is that it was an unlawful reason that kept Evergreen Cleaners to get paid, and the answer is provided by California law and this jury instruction. So let's see who is right. Number one, it says in the jury instruction that you just heard, this is called actual fraud. To establish this claim against Bobby's Discount Cleaners, Evergreen must prove all the following. Number one, that Evergreen has a right to payment from Bobo Brothers for $1.5 million. Now you remember, Bobo Brothers are the people that ordered the stuff. You didn't hear any questions about its quality. You heard that maybe it wasn't as good as it could be, but not any questions as to whether the money should be paid. The evidence showed that the money was owed. That, number one, we submit, you should find, is true. Number two, that Bobo Brothers transferred property to Bobby's Discount Cleaners. And didn't we see those bank accounts, $800,000 emptied in 5 days? Now you have had your own business here. You have seen how other business operates. Why would you empty $800,000 in 5 days? And why would you pay the lease of Bobby's Discount Cleaners instead of the lease for Bobo Brothers? Remember, Bobo Brothers was still in business, and yet its money left the account and paid for the lease of Bobby's Dry Discount Cleaners, a different business. So we submit that number two, you should find that Bobo Brothers transferred property to Bobby's Discount Cleaners. Number three, that Bobo Brothers transferred property with the intent to hinder, delay, or defraud one or more of its creditors. Well, you saw how frustrated Bobby was with Brett's indecisiveness. You saw how Bobby was determined to launch his own business and in fact use the assets of Bobo Brothers to launch it without paying any of their creditors. You saw he didn't like Evergreen, you saw he didn't think it was any gosh darn good, and you saw the emotion in his voice when he said that. How emotional he was. Did he have an intent to keep those guys from being paid just so he could launch his own business, even if the law said otherwise? Well, we're here to do the right thing. And we submit that number three, there was an intent to hinder, delay, or defraud. Number four, that Evergreen was harmed. What was the harm to Evergreen? That's a pretty simple one, right? $1.5 million owed. How much got paid? Zero. We submit there's plenty of harm to go around. And number four should be a yes. And number five, that Bobo's conduct was a substantial factor in causing Evergreen's harm. Well, Bobo transferred its money to Bobby's Discount Cleaners. And let me point out here, you don't have to find that Bobo Brothers did something because Brett or Bobby did it. You just have to find whether in fact that was done. So what number five is really saying is, did Bobo Brothers actually transfer money to pay the bills of somebody else? Were those bills paid with money from Bobo Brothers, but in fact the value went to Bobby's Discount Cleaners? We submit that happened when those $800,000 left the account in 5 days, paid in advance. Why would you pay 10 months in advance for dry cleaning? Why would you pay your employees in advance? Just more intent to defraud the creditors, more intent to use the money from Bobo's to establish a competing organization. And we think that if you answer these 5 points and line up the evidence that you've seen under those 5 points, that you should answer the special verdict form over here. Yes, there was an intent to defraud, and yes, there was a transfer that violated the law. Thank you very much.
Thank you, Mr. Stein. Steve?
Ladies and gentlemen of the jury, again, this is the last time I get to speak to you directly. Mr. Stein will have one more opportunity because it is his client, again, that has the burden of proof to establish that Evergreen is owed money by my client, Bobby's. And that is why he has a second shot. It is not my burden to prove to you that my client doesn't owe the money. It is Mr. Stein's to prove to you that the money is owed rightfully by my client, even though my client didn't order this material, never got it, never received it, never used it. Now, I also want to thank you because I've observed all of you. You've paid very close attention to the testimony. You have reviewed documents, and you will have those documents with you in the jury room. And you will also have the opportunity to have portions of testimony that you feel are important read back to you so that you can make your decision based on the evidence. Now, you've just heard an excellent, and it was an excellent closing argument by Mr. Stein. It's not a surprise. Mr. Stein is a superb lawyer. But this is not about how good a lawyer Mr. Stein is or how good a lawyer I might be. This is about the evidence that has been admitted in this case, the testimony of the witnesses that you heard, and the documents which have been admitted, which again you get to take into the jury room with you and look at them again should you find it helpful. And it should be helpful. Now, what happens is that Mr. Stein has cited some testimony and some evidence. I'm not sure I heard that, some of that. I mean, maybe I missed something. I'm not sure we heard some of the things that Mr. Stein said was presented. That's up to you to decide. Again, you have the opportunity to have testimony read back to you, to look at the documents that have been admitted in evidence. Now, you have to reach the conclusions from the evidence. And the court has already instructed you that in order for you to find that my client, Bobby's Discount Cleaners, is liable to pay any money to Evergreen based upon orders placed by Bobo Brothers, material delivered to Bobo Brothers, not to my client, you're going to have to conclude, based on the evidence, that somehow, because there was a reallocation of assets between the two brothers, Bobby and Brett, between Bobo Brothers and the new company that Bobby owns, that Bobby started, that there was a specific intent on the part of Bobby, Bobo, or his company, his new company, Bobby's Discount Cleaners, to prevent or hinder Evergreen from collecting the money that Bobo Brothers clearly did owe. There's no question about that. They owed that money. And yet, Evergreen did not sue Bobo Brothers. They sued my client. Why didn't they sue Bobo? Think about that. What evidence is there that Bobby Bobo ever intended to prevent Evergreen from being paid what it was owed by Bobo Brothers? Where was the evidence of that? Did you see any evidence also where Bobby guaranteed Bobo Brothers' debts? See any evidence of that? You didn't, because there wasn't. Did you see any evidence that Bobby's Discount Cleaners ordered anything from Evergreen? You didn't, because Bobby's never ordered materials from Evergreen. So what we have is a lawsuit against my client for materials it never ordered, it never got, it never received value. Now, in order for you to reach the conclusion that my client is responsible, you must find that specific intent to hinder, delay, or prevent Evergreen from being paid by Bobos. What evidence was there of that? Did you hear any? Did you see anything? I think not. So I ask you to sift through the evidence and see if you find any evidence of that intent. And if you don't, as I believe you will not, because you cannot, because such evidence doesn't exist, then as the judge will instruct you, and as you will be guided by the verdict form, you cannot find in favor of Evergreen and against my client for the money that's being claimed, because there was no intent on the part of my client or its principal, Bobby Bobo, to defraud Evergreen in any way, shape, or form. Now you're going to hear Mr. Stein get up once again and do his level best to convince you that such evidence exists when clearly it does not. But you've all paid attention. You listened intently, and as I said, you have at your disposal the documents that have been admitted and the testimony that has been given. When you consider that evidence, what has been proven and what has not been proven, you will come to the conclusion, as I outlined for you in my opening statement, that there is no way in justice that you can hold my client, Bobby's discount cleaners, responsible for the unpaid debt that is clearly owed by Bobo Brothers to Evergreen. Thank you. We finished on time. Close.
This is where the judge gets to flip a coin, you know. Oh, all right.
Let me get my two-headed water out for you. Heads, I win.
So we have a few minutes left. Are there any questions that arose?
I have one
Please.
question. I've been practicing for 24 years. I'm a litigator, but I have an accent. English is not my first language, even though I know English better than any other languages. Do you think it's wise for me to bring that up to the judge, to the jury's attention in the beginning of the case, or should I just ignore it, or should I just? Why don't you get your opinion on it?
Well, if you feel that you are in any way handicapped, by the fact that you do have an accent, I would mention it to the jury and say, as you can clearly hear, I have an accent, and I will do my level best to make sure that my words are understandable. But, if it looks like you're not understanding, let the bailiff know, and that will be forwarded to me. So I will try even harder to make sure that you understand my words, because I'm representing a client. What we're doing here is extremely important. Justice is attempted to be achieved, and I don't want to have any penalty paid by my client or any injustice done because of my accent. I would say something like that.
And I would say the opposite. I would say, listen, that, by the way, is a great thing to say. Fabulous. I'd go into Vaudeville. I'd go into Vaudeville, and I'd talk about this great country we live in. And not about great country for immigrants, but rather this great country we live in because of jury service. And look at the ladies and gentlemen jury. And by the way, how many people in this room had a grandparent that was born abroad? I had 3 of the 4. How about yourselves? Any had a grandparent born abroad, right? And what year was that? Was it about 1900 to 1920, maybe? How about you? How about year? Then?
06 to 08.
All right, but you may notice my accent. I'm that grandparent. The America continues to revitalize. Now, does anybody get bothered by my accent? Do you have any trouble understanding it? My son sometimes tells me he can't understand me, but that's usually when I'm telling him to go to bed. So if you once again, look at your themes, look at the society, look at what they're seeing on CNN, look at what they're seeing on Fox News, and see how to plug into those themes in a manner that helps you. I love my grandparents. They were great. I never understood my grandfather's English. He was so bad. But I nonetheless sat with him all the time. And I think that's what you do, is you bring that up as part of the American experience and the renewing of the American experience. It's not just history, it's what we're doing today. And of course, what is fundamental throughout the time, in the past and the present, jury service. It's always been there.
Thank you.
That's a good response, too. Very good.
Elizabeth.
With regard to Voidar, what is your experience, Judge, on how often counsel is actually allowed to ask questions? my experience has been the judge usually conducts the voir dire.
Have you been in federal court or state court?
State court, well, both.
Yeah. Well, the judge has the responsibility of asking the basic questions. Ladies and gentlemen, you're going to answer the questions on the wall. What's your name, your spouse, what's your or significant other, where do you live, what's your employment? My sense was that I preferred to let the lawyers ask the questions because they knew what was significant to them. And I let them ask the primary questions and the preliminary questions, and I would do the preliminary questions, they would ask the more detailed questions. The other thing I would point out, however, is if there's a topic that's uncomfortable, that's critical to the case, and the lawyers may feel uncomfortable bringing it up because it would make the juror feel uncomfortable, the potential juror, prospective juror, I would entertain the lawyers to ask me to ask those questions. And that, by the way, that's something that you may want to consider if there's a particular topic in your case. Certainly not this one, but if there's perhaps it's a civil assault case or a sexual battery case where it's uncomfortable, something may come up that's uncomfortable. Ask the judge to ask those questions. Submit the questions to the judge in writing and say, I'd like you to ask these questions, and I may follow up. In federal court, many judges don't allow questions at all. They do all the voir dire. But in state court, we're supposed to give a reasonable amount of time.
Which is usually how long?
Let me ask you a question. I've been in trials where the state court, where the judge wants in advance a list of questions that counsel intends to ask, and will opine on whether it's blessed or not, or may edit those questions as he or she chooses. What's your thought on that?
This doesn't have to be a judge we were talking about earlier, was it?
I'm not
maybe.
going to say. Could be.
Well, I'll tell you later. I've never seen anyone do that. I've never heard of anyone doing that. And I don't know that there's any law that says or rule that says that that's the way it's to be done. I think our rules say that the judge shall allow an opportunity to question the prospective jurors. That's all it says. It doesn't say for how long. In criminal courts, they have been pretty restrictive. When I was first appointed to the bench, I was in a criminal assignment because all judges in Los Angeles County started in criminal, about which I knew nothing. And they were very restrictive in the amount of questioning the jurors could do because the judges were supposed to do most of it. In civil court, my experience has been that the judge has his or her own thoughts about how long it should go. I'm certain that you would get at least 20 minutes to a half an hour with your jury panel. But if you've got a six-pack, as we call it, you've got 18 people in 20 minutes, you've got a minute and something seconds for each juror. That's not very long. But jurors get very bored with voir dire because they believe that they're just trying to be prejudiced by the lawyers. Jurors don't like voir dire very much. And judges want to just get through it and pick 12 reasonably fair people who can listen attentively and apply the law. So I think probably a little takeaway is be sure to talk to the judge beforehand and ask him or her how much time he or she, you go to judicial college, you learn it's one word, him and her, he and she, it's all one word, will allow for questioning of the jurors.
Well, gentlemen, thank you. We're out of time, and thank you everyone for coming this evening. Please join me in giving a round of applause for our panelists.